Almost all relevant admissible evidence helps one side and prejudices the other. But can some relevant evidence be so prejudicial that it's no longer admissible? The Third Circuit addressed this question in McQueenie v. Wilmington Trust Company. Francis McQueenie worked on a supertanker. The supertanker was owned by Wilmington Trust Company. McQueenie sued Wilmington, claiming that a work accident had seriously injured his neck. Wilmington disputed that the accident happened as McQueenie claimed. Initially, McQueenie was the only accident witness. Right before trial, McQueenie claimed a coworker, Mario de la Cerda, had witnessed the accident. At a deposition, de la Cerda confirmed McQueenie's version of events. Wilmington then produced crew lists showing that de la Cerda wasn't even part of the supertanker's crew until 3 months after McQueenie's alleged accident. This evidence indicated that de la Cerda's deposition testimony was false. Wilmington asked to present evidence and argument at trial that McQueenie had suborned perjury by getting de la Cerda to provide false deposition testimony. The district court found that whether McQueenie had suborned perjury was likely irrelevant to whether he'd been injured on the ship. In addition, the court found that the deposition evidence was unfairly prejudicial because it could cause the jury to think incorrectly that the case issue was whether de la Cerda had lied, instead of whether McQueenie had been hurt. Under this view, even if the deposition evidence were relevant, its slight relevance was substantially outweighed by its potential for unfair prejudice, which made it inadmissible under Federal Rule of Evidence 403. Accordingly, the court excluded the deposition evidence and arguments that McQueenie had suborned perjury. The jury found for McQueenie, awarding him over $300,000. Wilmington appealed to the Third Circuit on multiple grounds, including alleging that the perjury evidence should have been admitted.